last day of Justice Camp 2020. I'm sorry I had to miss yesterday, but I heard it was great, and I trust you all agree. I want to thank again Celia Rhodes and Sarah Johnson for yesterday's presentation on criminal law. And I want to thank all of the excellent speakers we've had this week, giving up their valuable time to share their wisdom, their expertise, and their experience with you. I have a few other thank yous I'd like to make today on this last day of Justice Camp. One is to my excellent co-chair, Scott Sternberg. Scott had the brilliant idea to take this online this year when we realized we couldn't reopen the courthouse for this purpose. Scott, if you could go back one slide. And I want to thank him for his technical expertise and for co-hosting and answering your questions all week. I also want to give a shout out to somebody you haven't seen yet this week, but who is behind the scenes doing all the heavy lifting, and that is Amanda Kaiser, the executive director of the New Orleans Federal Bar Association. And finally, thank you to you, all of our live or YouTube audience, for participating and watching, especially those of you who have been participating this week on Zoom. It has been so much more fun having you out there with us, answering our questions, asking questions, raising your hand, taking our surveys. We see the same names day in and day out, and we so appreciate that you stuck with it all week. And we hope that we've inspired in you an interest in a career in law as either a lawyer or a judge or a probation officer or a police officer or an agent or an investigator. The sky is the limit, and we will be mailing certificates of attendance to you. All right, we have a question on the screen, and I don't want you to Google the answer. I'm going to give you a very short fuse to answer in the chat room. Who can tell me what very important constitutional amendment was ratified 100 years ago this summer? Write it in the chat if you know. Ah, awesome. We already have a correct answer. That is the 19th Amendment. That's right. And write in the chat if you know what the 19th Amendment accomplished. Take it off the screen, Scott.
Oh, sorry. It's automatic, Judge.
Oh. Okay. All right. Looks like we're frozen on the right screen. Yes, that's right. The 19th Amendment gave women the right to vote. Isn't that incredible that only 101 years ago, women could not vote in any federal election in the United States and in many state elections? That might sound like a long time ago to you who are 15 or so, but think about it this way. That was probably your great-grandmother. And for me, my grandmother probably didn't have the right to vote, at least for part of her life. Women worked for over 70 years to get the right to vote at the state and national levels. They staged marches. You can see some of these on the screen. They held protests and demonstrations and hunger strikes. If you'll flip to the next slide, Scott, women were even force-fed. That's what that image shows, a woman being force-fed through a tube in her nose to get them to stop the hunger strike because it was upsetting people so much. And finally, in 1919, the 19th Amendment was passed by the House and Senate in May and June. And then finally, in August of 2020, it was ratified and adopted. So I want you to think about how hard people have fought and are still fighting for your right to vote. And when you turn 18, please register to vote and use your voice. Every vote truly matters. All right, now let's meet today's presenters who are going to speak to you about several non-criminal constitutional rights you have. And I know you're going to find these really interesting. First up, Ashley Heilprin is a commercial litigator at Phelps Dunbar. Ashley loves the excitement of arguing matters in court and developing strategy for a really good, sound, creative defense. She also loves to travel, and one of the most interesting trips she has taken was to Havana, Cuba. And I agree, Ashley, I love Havana. Our other speaker today will be familiar to you. You've been seeing him all week. Scott Sternberg, here with one of his adorable children. He's been our co-chair of Justice Camp, and in his real day job, he is the managing partner of Sternberg, Naccari White LLC, which has offices in New Orleans and Baton Rouge. He focuses on business, general litigation, and media matters. And a lot of his media focus is involving litigation for newspapers, including the Times-Picayune and the Advocate. Scott holds degrees in journalism and law, which explains how he knows so much about free speech and the freedom of the press, as you are about to see. Scott has an LSU national championship ring with his name on it, which is somewhat mysterious since he didn't play any sports at LSU. But when he was president of the law school, he also sat on the LSU Board of Supervisors, and he got all the cool stuff they give out, and so he got a team ring. Scott advises he did have to pay for it, and he doesn't wear it, but, I quote, "It's pretty freaking awesome to look at." So good for you, Scott. I'm sorry you don't have it on camera today, though, so we could all ooh and ah over it. And now, Ashley and Scott, please take it away.
All right. Thank you, Judge. So glad to be here with my friend Ashley Heilprin today, talking about the First Amendment. Ashley and I were just at a conference together before this whole COVID thing started, learning about the latest developments in the First Amendment, and kind of learning about what new developments in the law, as we both represent media entities here in New Orleans and across Louisiana. This session is interactive. We have poll questions. We'd love for you to speak. We'd love for you to ask questions in the chat. Rachel Naccari is here, and as is Amanda Kaiser, to help curate those questions to us. And we're excited to take a part of your questions. But let's talk about the First Amendment as it actually reads. The First Amendment has 5 freedoms in it, right, Ashley? What 5 freedoms do you see in that First Amendment?
So we have freedom of speech, freedom of the press, to assembly, religion, and freedom to
petition that government.
Did I say 5? Yes, petition the government.
And it's tough because that last one is, petitioning the government for the redress of grievances is a weird one, but it's exactly what we lawyers do. And, we file lawsuits, or we go to the legislature, and, sometimes you as citizens will petition the government. So I put a poll up for you, that which of the 5 freedoms is most important to you. So all the attendees can now see the poll. If you wouldn't mind voting, I'll then share the results with everyone. I know personally the one that matters the most to me is speech. What about you, Ashley?
I would say the press. I think particularly with everything that we have going on in the news, the press is incredibly important. That's where we get our information from about both this pandemic, our safety, our health, and the press plays a very, very important role in keeping order and allowing us to participate in what's going on in our communities.
I could see a pretty good argument for religion too. Remember, this country was founded on freedom of religion, and part of the reason it was even settled. Here are our poll results. Speech, the clear winner, but right behind it, petition, religion, and assembly. Press, not a big, not a popular freedom with our audience. Hopefully, we can.
Well, hopefully, in our presentation, we'll change a few minds about why freedom of the press is important.
Exactly. So anyway, that's the First Amendment. It's the First Amendment for a reason. It's the First Amendment because the first 2 amendments weren't ratified by the states, and so that's how it became the First Amendment. But I think it's the most important, and that's why being the first is so important to me. Ashley, you want to talk a little bit about state action in the First Amendment?
So when we're talking about regulating speech, one of the questions that we have to ask is whether or not there's state action, because in order to have what could be an unconstitutional restriction on free speech, we have to first look and see, is the entity that's seeking to restrict that speech actually a governmental or a state actor? And that's different from here in this picture, we have an example of, for example, your mom telling you you're not allowed to say something. I know when I was a child, I have two sisters, and my mom did not like us to use certain words. And particularly when I was talking about my sisters, or if we were talking about each other, she didn't like certain words. And so my mom would say, you are not allowed to use these words. But there's a big difference between my mom in our home saying you can't use particular words and, for example, the city of New Orleans passing a regulation that says you're not allowed to use, these particular words or express these opinions.
Right. And, here we have a picture of some protests from a couple of years ago relating to immigration. That's a great example of state action. You've got a policeman right here as opposed to your mom. Now we want to move on to this conduct as speech question. There's a lot of ways to talk, right? You can talk like Ashley and I are talking as well, but there's also ways to use conduct to express yourself. So we want to give you an opportunity to open up the chat and tell us what you think, some examples of conduct as speech. What do you think about that? What kind of conduct is speech? Have you ever seen somebody do something with their maybe their hands or
different gestures, and a gesture that may convey a message, whether positive or negative, could be an example of conduct that is speech.
Right. We see somebody, Thomas Massey says clothing. Yeah, clothing could be a way to express yourself. We saw NFL players kneeling during the national anthem. That was certainly conduct. That was speech. We're going to learn a little bit about, saluting the flag or giving the pledge. Rallies, just showing up somewhere can be speech. Conduct as speech is required to convey a particularized message that will be reasonably understood by the recipient. The spirit animal, I think that too. I definitely think that's free speech. Now we're going to move on to questionable regulations or what the government can't do. When we talk about state action, we're saying that private actors can't really affect your freedom of speech, but the government can. And so the question that I want to ask you first, and I'm going to put a poll up, is should the government be allowed to tell the press or an author that they can or cannot print something? This is an important question, and I'd really like to see your answer. So the poll is up right now. Let's go ahead and see those answers. All right, looks like almost everyone is saying no. We got a few yeses. Couple yeses. Couple of qualifiers in the chat. No, unless it's an endangerment to the country. That's a good point. All right, I think we've got enough votes here, so I'm going to end the polling and I'm going to share the results. 73% of you said that the government shouldn't be able to tell the press or the authors what they can, when they can and cannot print, or what they can and cannot print. And that's what the Supreme Court has said too. They've said that there's very, very small exceptions to this rule. And, the only real case, that we'll talk about here is about, endangerment to the country itself. And, there was a case in 1971 called New York Times versus the United States, where actually the, let's see, share results, where actually the government did say that the New York Times and the Washington Post sharing information would be an endangerment to the country. And the Supreme Court said that they could publish it anyway. But there's another case in the 1990s where a magazine was going to print basically the plans for how to build a hydrogen bomb. And that's the only time that we've seen a prior restraint, which is what these are called, upheld, because as we heard in the chat, sometimes there is an endangerment to the country and it can be prohibited, but it's very rare that the government can prohibit people's speech, right, Ashley?
Right. I mean, one example that y'all might be familiar with that's a little bit more recent is WikiLeaks and Julian Assange. It's a similar case that's still percolating, but reminds me a lot of the New York Times case in the 70s and publishing government records, military records related to the Vietnam Wars, similar in many respects to what's been in the news lately in the last couple years about WikiLeaks and Julian Assange. So if you're interested in some of those arguments, that's something that I would definitely suggest looking up.
And we saw a really recent prior restraint case just about 2 weeks ago as it relates to coronavirus. The mayor of Louisville, Kentucky said that you couldn't have church services. And a church there sued the mayor and said, we want to have drive-in church services. And the federal judge there said that you have to allow drive-in church services because to allow otherwise would be an unconstitutional prior restraint on the right to exercise your religion. The judge didn't say that 50 people could get together at a church because that is obviously a danger to people because of COVID right now. But the court said that you had to provide alternative channels of communication for those preachers and those folks who wanted to exercise their religion. And then we've also seen some kind of scary images lately out of Michigan, some protests with, I believe that's an M16 assault rifle. Having an assault rifle with you at a protest is considered speech in some form, and they can't really prohibit that. It's kind of an interesting problem, but prior restraint leads into our next question of what the government can regulate based on content and what it can't regulate. It can
Scott,
regulate.
I think we have a question from Caleb, if you have time.
Sure, absolutely. Go ahead.
Okay, Caleb, you're good to go. Oh, maybe not.
Caleb, do you want to chat it to us or you want to speak it?
Yeah, for some reason it's not letting me unmute Caleb, so.
Let me see.
Caleb, if you like, you can type the question into the chat.
That's interesting. It won't let me unmute you either, Caleb. It must be something with your hardware. Would you type your question into the chat like Ashley suggests? In the meantime, we'll go ahead and keep talking about content-based versus content-neutral so we can get things moving. Whether the government is regulating speech turns on whether it's based on the content of the speech or the actual time, place, and manner of the speech. This is really important. There's a big difference between regulating speech based on what is said versus where it's said or how it's said. And so the next question I have for you is a where it's said or how it's said question. And this is poll question number 2. And I'm going to launch this for you right now. All right, what do we think about this DC law that bans individuals from displaying signs criticizing
foreign governments? So if a statute bans individuals from displaying signs that criticize foreign governments, within 500 feet of a foreign embassy, do you think that that would be a content-based regulation, and so perhaps not okay, or a content-neutral regulation? What do y'all think?
Okay, looks like 64% say it's okay, 36% say it's not okay. What do you think, Ashley?
So I would say this is not okay, because the emphasis here is on signs that are criticizing foreign governments. So that is regulating the speech based on the type of speech that is being made. So if you had a sign that said, "Yay, I love this, what a XYZ country," then you'd be allowed to stand within 500 feet of the embassy with your sign. But if you had something critical to say, like, "Oh no, I don't like this government," on your sign, then you wouldn't be allowed to. And so in this instance, this statute would be a content-based regulation. And I think one thing, I don't know if we said this yet or not, but the difference between when you have a content-based or a content-neutral regulation is the level of what we call scrutiny that the court applies to that particular regulation to determine if it is consistent with the Constitution or whether it violates the Constitution. And so
Right.
if you are regulating speech based on the type of speech, so here, is it critical of a foreign government, or is it, favorable? That would be content-based and subject to a higher level of scrutiny. If it was content neutral, simply saying you're not allowed to have signs within X number of feet of the foreign government, period, or perhaps during these hours of the day, perhaps during business hours, you're not allowed to do that, then that would be content neutral, because it applies to everyone regardless of what's on the sign, whatever their speech is, and is really regulating what we call the time, place, and manner of the speech in question.
Right. Like this next question we have, which I'm not going to put a poll question up, but it says that that you can't put any signs up within 20 feet of an embassy. What do you think about this one, Ashley?
So this one would be content neutral because it applies to everyone equally, and it's saying, hey, there's a legitimate concern about federally funded security for these embassies, and we don't want anyone within a certain distance. It doesn't matter if your sign is critical of the foreign government or favorable to the foreign government. Across the board, regardless of what your sign says, you need to back up outside of the 25 feet range.
Awesome. So our next question talks about content-based restrictions and asks, are there certain types of speech, sorry, I'm skipping this part. Are there certain types of speech which are illegal? And if so, which ones? If you can chat us what types of speech that you think would be illegal, and Ashley and I will talk about them. Okay, we already got a suggestion, hate speech. That's a good one. We're going to talk about that one in just a minute. We got one in the Q&A. Death threats, also a very good one. Death threats are illegal, right? Right, Ashley?
Yes.
As long as it's
I think we have that in our presentation as well about fighting words and true threats. Should make those.
Great. So let's talk a little bit about speech on campus. Since you are all hopefully going back to your campuses very soon in August, for next school year, we want you to know about your rights on campus very briefly. Your rights on campus started with West Virginia versus Barnett in 1943. A young man who's a Jehovah's Witness did not want to salute the flag. And the Supreme Court said that the First Amendment does not require someone to have unanimity in any topic or belief. So making a child salute the flag was not legal, according to the Supreme Court in 1943. Then, just a few years later, in Tinker versus Des Moines Independent Community School District, that was not 1943, that was 1968, I believe. Students wanted to protest the Vietnam War, and so they wore these black armbands to school, and they were kicked out of school for it. And the Supreme Court said that kicking them out of school wasn't constitutional, right, Ashley? Why did the Supreme Court say it was unconstitutional to remove Mary Beth Tinker and her family from school?
In this case, they said that, we have our First Amendment rights just, in school, and it doesn't, I think the justice said, it can hardly be argued that neither students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate.
Great. All right. And so we have some more student speech cases. Hazelwood versus Kohlmeyer deals with a newspaper at school where it was part of a class project. And they said that that wasn't free speech, that it was like graded work. And because the teacher was grading the work, that they could censor or restrict free speech in schools because it was part of the curriculum. So we have a quick question for you, which I believe we have a poll on. You are a student at Most Blessed Sacrament, a Catholic school, and your principal has instructed that there will be no discussion of immigration because the debate has become too harsh. So what do you think? Do you think that's okay, or do you not think that's okay? I'm going to launch this poll right now, and let's see what you have to say. All right, we're getting some good responses here so far. It's about 50-50 here. Let's go ahead and end the polling. Share the results. All right, so Ashley, 63% of our voters say that this is not okay. 38% say that it is okay. What do you think?
I think we have to go back to the beginning when we talked about state actors and dig into whether or not this particular school is a state actor.
And it's probably not, right? Because it's a Catholic school.
Right. I mean, I think there could be some intricacies there, but generally I would say no.
But if it was a public school, this would definitely not be okay, right?
Mm-hmm.
Right. They couldn't say, we're not going to talk about that because it's become too political. That would be a very blatant violation of your First Amendment rights. So now we're going to move on to incitement, fighting words, and true threats, which is some of the suggestions that y'all came up with earlier. First, we're going to talk about Brandenburg versus Ohio, which is a very famous case, mainly because a couple of members of the Ku Klux Klan got together in a barn in Ohio and said that they were going to march on Washington and take back the United States for the Caucasian race. And what happened in Brandenburg? Did that march ever happen, Ashley?
No. So the interesting thing in Brandenburg is that the court looked at whether there was an imminent lawless action to determine whether or not the speech was protected under the First Amendment, and then whether or not it could be restricted. And the court held that hate speech, which I think someone mentioned in the chat earlier, is protected under the First Amendment as long as it does not provoke violence. And so the question of imminence is a time question. And so if you are doing something, but there's no imminent threat, even if you have a group like the Ku Klux Klan that may be perceived as inciting violence, that if that threat is not imminent, then that speech is protected under the First Amendment under the Brandenburg versus Ohio case.
And an interesting thing about Brandenburg is that, you know, there were a couple of guys in a barn wearing Ku Klux Klan outfits that they were saying they were going to march on Washington, but there was no likelihood that they were actually going to march on Washington, because if four guys in white suits marched on Washington, you know, they would have the entire, you know, American military there to obliterate them. So it wasn't really likely to incite or produce lawless action. But, you know, I mean, look, we're dealing with this right now. I mean, we talked about this guy earlier. You know, I have a tough time with this. Like, how is this guy not incitement, Ashley? I mean, what do you think? I mean, is he telling people to, you know, to overthrow the government or hurt people by wearing this gun? It makes me very uncomfortable.
I think it's tricky. I mean, I think you have people on all sides of the spectrum who have different views about guns, and perhaps someone would say, look, this is my lawful right to carry, and I'm not telling people, you know,
Right.
shoot anyone. But I also think that an M16 assault rifle certainly conveys fear and intimidation.
Right.
And so carrying such a large military assault rifle, to me, is an expression of an intent to evoke fear.
I've got to say, it makes me feel uncomfortable, but that's part of what the First Amendment does sometimes. It protects things that make people feel uncomfortable, because this man, you know, even though he does have an assault rifle, he's not pointing it at anyone. He's not saying, let's go kill a bunch of people or let's overthrow the government. He's kind of just standing there. And so I would say that this probably is not incitement. But I think that it very easily could be if he was holding up a sign or if he was saying certain things, that he probably could be inciting people. Let's talk about Cohen versus California, because that's definitely a very interesting case. This guy, Cohen, got a traffic ticket, and he walks into the courthouse in Los Angeles with a jacket on that uses the F word, and it says, F the draft. He was arrested for disturbing the peace, and a very famous case in the First Amendment, because the state of California argued that his leather jacket, black leather jacket that said F the draft on the back of it, was fighting words, or you know, incited this vulgar and like response from the person who saw it. And the Supreme Court didn't agree with California, right, Ashley?
Correct. So the Supreme Court looked at whether or not the F the draft statement, although perhaps offensive to some, whether or not that actually was disturbing the peace. And there the statute prohibited maliciously and willfully disturbing the peace and quiet of any neighborhood or person by offensive conduct. And the court reasoned there that although the language was perhaps offensive or provocative, that it wasn't directed to anyone specifically. And there was no evidence that, you know, a large number of people in the general public would be provoked to do something in response to that statement.
Right. It wasn't likely to cause any kind of imminent harm or imminent response. There's a more recent case that Judge Van Meerveld and I have talked about in the past of aloneness.
Oh, we have a comment.
All right. Let's see what we got. I don't see it.
So Leon said, when a few of the Klan marches, it attracts many like-minded people. So yes, and when we go back to the slide that Scott put up in the beginning about what are the 5 freedoms that the First Amendment protects, one of them is assembly. So yes, when the Klan marches, it attracts like-minded individuals, and those like-minded individuals have a right in general to assembly.
Right, right. Even if it's something that we all don't agree with, they still have a right to assemble. So it's a very interesting, the First
Let's
Amendment.
pause for just a second and talk about why it's important that even when you don't agree with the message that a group is promoting, why they have the right to convey their message, even if you don't agree. And I think one of the things that is really important to remember is that when we regulate speech, we talked about content-based and content neutral. When we regulate speech based on here's the message that's being conveyed. So I don't like this message, so I want to restrict this group of people or this person from conveying that message. And there's a danger that as time passes, the pendulum swings, those people who are in power shift, then I could be next on the list. And someone could say, oh, well, I don't like the speech and I don't like the message that, Ashley's portraying. And so I'm going to restrict her speech. And so in order to ensure that we all have freedom of speech and freedom of assembly and religion and so forth, we have to take a content neutral approach to the regulation so that we're not picking and choosing based on the message that is being conveyed. Because if we do, then we run the risk of, okay, in this moment in time, this is an unpopular opinion, so we're going to exclude it. And then fast forward, now my opinion is unpopular and now I'm going to be excluded. And when we do that, we erode the freedom that we all want to enjoy.
Right. Ashley and I are old enough to remember when rap music first came and became a big thing among our age group. And at that time, you had the President of the United States and the Vice President of the United States and the First and Second Lady driving a steamroller over 2 Live Crew records. Ashley, you're probably not old enough to remember that.
Yeah, no, 2 Live Crew, also NWA. Yeah. I mean, they had a song that the President of the United States was saying was inciting violence, right, because it said to F the police. And sorry, Scott, to interrupt you, but yes.
No, that's absolutely, I mean, that's absolutely the point, because as we learned in Cohen versus California, the famous quote from Cohen is that one man's vulgarity is another man's lyric. And so, in the 1990s, when, the establishment and the people were against, rap music and R&B, that has now become the dominant form of music of American society today. And so it just goes to show you that, sometimes we're wrong as a society about things, right? We're very wrong. And the First Amendment allows for people to express themselves, so that way when we get it wrong, we can eventually get it right. And that's something that when the colonies broke away from England, they really wanted the ability to try new types of government and print their own money and have these ideas like freedom of religion that they weren't allowed to have under King George. And so, there are numerous examples that we could give you to show that at one time it was a bad idea or shunned or illegal to be a communist or a socialist, for example. Now we have people who are, communists and socialists, and they're not scared to go outside of their houses like they would have been in the 40s and 50s. Right, Ashley?
Exactly.
Right. And so that's why, sometimes some of this stuff makes you extremely uneasy. And I always like to cite, that the ACLU, which represents numerous people in First Amendment cases, has defended the Ku Klux Klan and the Nazis because they believe so strongly that even though the Ku Klux Klan and the Nazis are deplorable and the things that they stand for, we don't stand for, that the right to free speech is so important that we have to make sure that no one is discriminated against, even people who espouse just terrible, terrible ideas. And actually, that's a pretty good lead into hate speech. Don't you think, Ashley?
Yeah.
Okay, so let's talk a little bit about hate speech. You know, we had a recent case in 2017, you know, that dealt with speech that demeans on the basis of race, ethnicity, gender, religion, age, disability, or any other similar ground is hateful. But the proudest boast of our free speech jurisprudence is that we protect the freedom to express the thought that we hate. And here's an example of some from a different case in 2019 of some things that the trademark office was allowing and not allowing, just to show you what they thought was hate speech. They rejected baby al-Qaeda and cocaine as a beverage, but they allowed, you know, Jesus died for you or dare to resist drugs. The government up until 2019 was discriminating based on the content of the speech because they thought it was hate speech, or because they didn't like the content of the speech and they thought it was bad for children. And then the Supreme Court in 2019 said, you know, you can't do that. You can't pick one side of the argument and say, okay, you get to fight, but the other side doesn't. Right, Ashley?
Correct. I think one of the interesting things also in the trademark cases is that the test about whether or not these, you know, potential marks were offensive was whether it was at the time that it was created. And think about how time evolves and how what we might find to be hateful or offensive changes, you know, based on what era we're in. I know I certainly have read old Louisiana cases that, you know, refer to a child of unwed parents as a bastard, and that, you know, might be offensive, or many other terms that today we would say are offensive or hateful, but at the time that, you know, those terms were being used, perhaps it was accepted. So yeah, I think that this is certainly an interesting question.
Right.
And I think it emphasizes what we talked about with the importance of being neutral to the speech.
And you know, there's a very interesting case that really strikes a number with me, Snyder v. Phelps. This poor man, his son, Matthew Snyder, is killed in the line of duty in Iraq in 2006, serving our country. And the Westboro Baptist Church, which is a church that opposes gay rights and thinks that gay people being in our military is causing basically the end of times, decides to protest his funeral. And so to demonstrate their beliefs, they picket military funerals fairly regularly. And you may have actually heard of these folks before. They think that their religion requires them to you know, inform people. So they go to the local authorities and they say, hey, there's going to be a funeral. We're going to set up on a public park by the funeral, so that way everybody who drives by going to the funeral is going to see our signs. And those signs say things like, God hates the United States, thank God for dead soldiers, God hates you. They sing hymns, they recite Bible verses, but they also got a permit. They got a permit from the local municipality, and the family drives by and sees that, and they sue the Westboro Baptist Church because not only had they lost their son, but they had also been subjected to these horrible signs. And so the question that I want to ask you right now, these signs, while Westboro was picketing Matthew Snyder's funeral, they argued at the Supreme Court that this had everything to do with a matter of public concern and that they were talking about something that mattered. And the Supreme Court had to make a decision whether or not Westborough's signs and comments were a matter of public concern and entitled to protection under the First Amendment. So I've launched the poll for you. Let's go ahead and see what you think. Were Westborough's signs, based on what you've learned today, protected or unprotected?
Scott, do you see the comment in the chat asking if this is legal?
So that's a good question. I mean, they got a permit. So, you know, there's certainly nothing wrong with standing on a public street, which is a public forum, and expressing your views on politics, on social issues, on what color you like best. We've got plenty of cases that say that the First Amendment allows you to assemble on public property. But the question here is whether or not Westborough's signs and comments are protected by the First Amendment. I think we've gotten enough answers. So I'm going to end the polling and I'm going to share the results. 83% of you said that they are protected. These signs are protected. And 17% of those who voted said it was unprotected speech. Ashley, what do you think?
Well, I'm curious before, before we get into what the court held, if the folks who voted no or yes, I guess either way, want to put in the chat box why. And I think this is a really, really interesting case, and I'm curious as to why, why you voted one way or the other.
Yeah,
great. We'll give you just a couple of seconds.
A great point. So if anybody wants to be recognized, you can raise your hand and express yourself, or please put in the chat box why you think that the court ruled the way you did. You voted yes or no. Tell us why, and then we'll talk to you about what the court did. Okay, well, it doesn't look like we have many volunteers for this.
Okay.
Ashley.
Well, in this case, the court looked at, in particular, I think Scott mentioned it, whether let's see. So Amari said the signs were pure hate speech and should not have been able to said, and someone has just died for this country. So you're right. They were perhaps offensive signs, and they were at a funeral for a military member. But, and Scott, I don't know if you can go back
Sure.
to where we had the signs or examples. But if you notice, the signs aren't talking directly about Matthew Snyder. These are general signs that are talking about the military and sort of the morality and religion related to the United States. And so in this particular case, the Supreme Court looked at, okay, was the content about a matter of public concern or purely a private issue? So they were, at a funeral, and were they talking about this specific military member? And there the court said that speech dealing with matters of public concern, whether it's relating to, let's see, we have a comment about intentional infliction of emotional distress. So that was a claim that by the father that by having these picketing signs at the son's funeral, that you were trying to cause me emotional distress.
Right, and that's the claim that survived and made it all the way to the Supreme Court, was whether or not the Westboro Baptist Church had inflicted emotional distress upon the Snyder family. And
or whether that speech was protected as free speech. So even if the family had emotional distress, was the speech that allegedly caused the emotional distress protected under the First Amendment? And so the court looked at the content of the speech and the context and the form, and they noted that this was really about a matter of public concern and not a private matter specific to Matthew Snyder.
And that's why the Westboro Baptist Church won this case, because the Supreme Court said, even though this is deplorable speech and we don't agree with it, we can't say that one side is right and the other side is wrong, which is very similar to what happened in the last case we're going to talk about, which is RAV versus City of St. Paul, in which an actual cross was burned in the family of an African-American family's front yard in 1992. So Bill Clinton is about to be president of the United States. Michael Jordan just won his first NBA championship. This is 1992, and there's a cross burning in St. Paul, Minnesota. And they had a law in St. Paul that said that you couldn't place on public or private property a symbol, including a burning cross, which or believe would arouse anger, alarm, or resentment in others on the basis of color, creed, religion, or gender. And they made it a crime. And what happened in this case is pretty interesting. Do you think that this law, and I don't believe that I have a poll question. Let me see. Stop share results.
Oh, we have another question, Scott.
Okay, sure.
I think this is related to the Snyder versus Phelps case.
Okay.
And was the location of the protest, of where they protested, factored into the court's analysis? So they were lawfully gathering on a public street.
Yeah, they were in a public park on a public street, and they had a permit. And so, yeah, the answer to that question is yes. The fact that they had every right to be there to have a picnic or talk about baseball or whatever, gave them a lot of cover in that case.
Now, do you guys think that the answer would be different if the Westboro Baptist Church didn't stay on the public street and instead came inside of, let's say that the funeral was being held at a private cemetery or a private church, and they came inside the building with their signs?
Right. I think it would be different, Ashley. Mm-hmm. What does everybody else think?
What do you guys think?
Anybody want to raise their hand and be recognized? I can.
I think that the question of where they were is definitely part of the analysis, and the question that was posed to us about was the location taken into consideration in the court's analysis. And so what actually happened was that the Westboro Baptist Church had a permit. They were on a public street in a public place, and they were lawfully gathering. But if they weren't, then perhaps the outcome could have been different.
And in RAV versus City of St. Paul, 1992, that burning cross was in the front lawn of a local African-American family's house. So it wasn't on public property, it was on private property. And let me tell you, if you light a cross on fire in somebody's front yard, that is an extremely threatening, disturbing thing. But in RAV versus City of St. Paul, the Supreme Court found that this actual law that's on your screen right now was unconstitutional. Does anybody know why? Does anybody want to take a guess as to why this law was unconstitutional? Why do you think, Ashley?
So here we have a content-based regulation. So we're saying you're not allowed to burn a cross or post a swastika, which are symbols of hate groups, but you could be allowed to post a symbol of the opposite perspective, whatever that might be. And so it's a content-based regulation.
Right, and there were much easier ways to prosecute these people who put this cross in that family's front yard, right? I mean, they could have been prosecuted for arson or for damage to property, but that's not what the prosecutor chose to do. He chose, or she, it's actually she chose to prosecute under this bias-motivated crime ordinance. And so the Supreme Court puts together a ruling that says that law was unconstitutional. But here are a few things that we want you to remember about hate speech. The first one is that there is no hate speech exception to the First Amendment. Threats of violence and incitement to violence are not protected, but that has nothing to do with whether or not it's hateful content. It's got to be an imminent, likely to occur threat or incitement to violence. And hate crime laws can punish violence or vandalism, but that doesn't allow the punishment is just for hate speech. And that's really important, because even though hate speech is something that we're all against, if we have laws that criminalize certain types of speech based on their content, the First Amendment isn't worth the paper it's printed on. We can't have content-based regulations, or at least that's what the Supreme Court has said, right, Ashley?
Correct.
Okay. And so in RAV versus City of St. Paul, Justice Scalia writes, let there be no mistake about our belief that burning a cross in someone's front yard is reprehensible, but St. Paul has sufficient means at its disposal to prevent such behavior without adding the First Amendment to the fire. The idea that Justice Scalia is putting forth here is that the City of St. Paul should just prosecute these folks for arson and criminal damage to property. There's no reason why they have to pick one side of an argument or another. And Ashley, do you have anything to add to this slide?
No, I just think that I think it's an interesting issue, and as we are getting ready to wrap up, we want to think about the First Amendment protections that we have in the United States. But I know we don't have a poll here, but I imagine that many of you have social media accounts, and you post things on the internet that perhaps could be viewed. I know I have friends on my Facebook or Instagram in other countries. And so it's interesting to think about the protections that we have here that may also differ from what content is allowed in other places. And I think we are fortunate to live in a country where our approach to regulating content is supposed to be content neutral, and so that we can have diversity of expression and ideas, and in other places perhaps they don't.
Right, and this quote from Healy v. James, where the freedoms guaranteed by the First Amendment must be accorded with the ideas we hate, or sooner or later they will be denied to the ideas we cherish. And that is the all-encompassing quote that takes care of everything we have talked about today. Many of you have probably heard our next quote, which is our last slide for the day before Judge comes back and sends us on our way. But you know, Voltaire is largely attributed with this quote of, "I disapprove of what you say, but I will defend to the death your right to say it." And that is what Ashley and I do for a living. So it can sometimes be very trying, but there's a larger movement in mind, and there's a larger belief in mind, and that's why we do what we do. And for me, thank you so much for letting us speak to you today. Ashley, if you want to say anything.
Yeah, thank you. You know, it's been wonderful, and I'm glad that we had a chance to share with you a little bit about our love for the First Amendment and inspire you to continue to pursue a legal career in the future.
Thank you both so much. That was terrific. And it's interesting how so much of those images and the speech that you included does evoke such feelings of contempt and despair and revulsion, and yet how important it is under our Constitution that the majority of the time you do have the right to say such things. It's an interesting tension there between an individual right and the public good, and one we continue to grapple with as a nation. So I want to again thank everybody for participating. Amanda, could you jump on perhaps and let us know how the certificates will be handled? Will they go to everybody via email?
Or
via their
to mail them out. Everyone who sent me their physical address will get it mailed to them, along with a pocket constitution and a fun Cane's gift card for tuning in all week and hanging out with us. If you haven't sent me your mailing address yet, in today's email will remind you to send that to me. If I only have an email address, I will email you a copy of the certificate. You just won't get the extra goodies. And I will also send out the links to all the videos in today's email, so that you have them in one spot.
Judge, if I can put in a plug, everybody send the YouTube videos out to your friends so that we can get some good views. And I also want to thank Amanda Kaiser for all of her work, and especially thank Judge Janice Van Meerveld for all of her leadership and moderation and curating of this court camp that is so important to the Eastern District. Thank you, Judge, for doing this year.
Well, thank you. It has been a real pleasure. Thanks to all the speakers and these amazing kids we had participating. I think we have a couple of questions in the chat. I think we can answer those in writing. I'm going to cut everybody loose now. Best of luck with the end of your school year. Best of luck with your summer. And when you end up in law school and you are looking for good court-based experiences here in the New Orleans area, please reach out to me and remind me that you were part of Justice Camp. And I know we have at least one of you. To the young lady who participated live last year and has been online with us every day this week, I have a plan for you. So come back, everybody, if you can next summer. And again, good luck with everything. We'll see you.
Thanks,
bye-bye.
Yeah. Bye.